Hello, my name is Attorney Joe DeFranco. I am an attorney here in the Central Florida area, and I handle both personal injury cases and first-party insurance disputes. Personal injury cases could involve anything from a car accident to a slip and fall to a dog bite to an injury that you might receive at a business or some sort of public location. Again, I also handle first-party insurance disputes, and that can involve any type of dispute that a policyholder can have with their insurer. The vast majority of what I do are homeowners claims, but I also handle health insurance claims, life insurance claims, and claims involving damage to your vehicle. Um, in this field of work, I encounter a lot of questions regarding negligence and really what is negligence. And negligence is simply the failure to live up to a duty of care, a reasonable duty of care, to act, to be vigilant for, and in order to avoid injuring others. So it's basically just a reasonable level of care, reasonable duty of care that someone must employ to avoid causing harm or damage to others. Another case, branching off from that question is a question that is quite frequent, and that is, in the event that someone is partially liable for the accident, can they still bring a claim? And the answer is absolutely yes. In Florida, as with other states, the primary personal injury that most attorneys encounter are car accidents, and frequently you could have multiple drivers that are negligent. In a case where there's a two-car accident, the person that's injured could have, excuse me, been liable for the accident in some manner, and in that case, they can absolutely still bring a claim against the person that was involved in the accident with them, and depending on what percentage that individual's negligence is, they could recover fully for their injuries that are consistent with that individual's negligence. Another question that I get is who would be responsible for catastrophic injuries? Now, the answer is simply whoever is responsible for the accident, whoever is responsible for causing those catastrophic injuries. There are situations where, and particularly in Florida, we have a lot of uninsured motorists and underinsured motorists. And in the event that someone suffers a catastrophic injury, there is a high probability that the person who caused the accident may not have sufficient coverage to pay adequately for your injuries. For that reason, it's extremely important that you speak with an experienced attorney who's seen the situation before. He can advise you accordingly about what to do in these situations. There are avenues sometimes of approach in terms of utilizing other coverages, looking at other possible sources of recovery, looking at other individuals or other companies or entities that might have been negligent. So there are several things we can do sometimes when catastrophic injuries are involved that can aid the person. And although the primary person who caused the accident or who caused the injuries may be underinsured or uninsured at all, a lot of times there's still things that we can do. And for that reason, it's really important that you speak with an experienced attorney. Also, too, in terms of negligence, in terms of partial liability, in slip and falls, it's frequent and it's common that the person who actually falls is partially liable for the fall itself. They probably could have avoided it. There's a possibility that they could have prevented this fall with relative care. Even in those situations, even when the business is actually less liable than the person who was injured, there are still avenues of recovery that can be made. Again, it is vital that you speak with an experienced attorney before proceeding, so that individual can explain the situation and outline all your rights and your potential sources of recovery. Again, any questions that you may have, please contact our office. We'd be more than happy to speak with you. Again, this is Attorney Joe DeFranco, and thank you very much.